but it's not positive. How is everybody today? Who knew that tax increment financing could bring out such a great group? We are delighted to have you here with us today. My name is Jason Mumpower. I'm Chief of Staff for the Office of the Comptroller of the Treasury. We are very, very grateful that you were here. There are in this room many people I know, many experienced tax practitioners and professionals. There are people from city and county government, members of the legislature, and other esteemed folks. There's a lot of knowledge in this room about tax increment financing already, and we certainly appreciate you being with us to visit with us during this tax increment financing update that we're going to give today. We are holding this in response to demand and by virtue of the fact that we had this great crowd RSVP and show up. We see this demand exhibited in front of us. We'll try to do it regularly if it's something you want us to do again. Today we have a program designed to last through the lunch hour. However, we will stay as long as you want to stay if you have questions. Tax increment financing, of course, is a powerful economic development tool. It is a tool used to help create housing where there is a need for housing. And it is something that our office, the Comptroller's Office, in some cases has a role in approving. Not all cases, but some cases. And so that is how we interact. I hope when you came in and picked up your lunch or your name tag that you picked up one of our roadmaps to tax increment financing. Kelsey Jones will autograph these before you leave if you want him to. He's the author of the document. But we are, again, delighted to have you here. Our goal in the Comptroller's Office is to help government work better. And on behalf of Justin Wilson, the Comptroller, and myself, we welcome you. And we will look forward to visiting with you after the program. I encourage you here in the room, as many of you may not know one another, I know we have people from different parts of the state, to linger after the meeting is over and meet one another and call upon one another as you have different things happen in your communities, and you can perhaps learn from someone else's experience. I'm going to turn it over to John Dunn, who's going to tell you a little bit about the structure of the program. But again, we're delighted to have you here in the Office of the Comptroller, and we hope this session is beneficial to you. Thank you.
Thank you, Jason. I'm John Dunn. I'm the Public Information Officer for the Comptroller's Office. And again, I'd just like to echo Jason's welcome to you all here today. We're going to begin with a presentation that should last about a half hour or so, and then we'll have time for questions and answers after that. But I'd just like to take a moment and introduce to you the presenters today. Betsy Noss, who will do the primary part of our presentation, is an Assistant General Counsel in the Comptroller's Office of General Counsel. She's a native of Louisiana and holds her bachelor's degree from Tulane University and her law degree from LSU. She practiced 5 years of public finance law in the Texas Attorney General's Office before moving to Tennessee in 2013. After working with the Tennessee Attorney General's Office, she then joined the Comptroller's Office, where she handles issues related to tax incentive programs, utilities, and financial transactions. Joining Betsy today will be Kelsey Jones, who's the Executive Secretary of the Tennessee State Board of Equalization. Kelsey is also an attorney and attended law school in Memphis. He is most familiar with property tax law and helps manage the State Board's responsibility to hear statewide property tax appeals and review property tax exemptions. Please join me in welcoming Betsy and Kelsey.
Thank you very much, John, and thanks for coming today. Like John and Jason said, this is the first of its kind, so we definitely welcome feedback, and if you enjoy this, we'll have more and on different topics. Today's agenda, I'm going to give a brief overview of tax increment financing. This will be good for the newcomers. You'll get a good foundation. For people who do this for a living, this will probably just be a mild refresher. I'm also going to go over the Comptroller's statutory duties related to TIF, and then Kelsey Jones is going to pop in and do the Q&A at the end. And the Q&A is made up of questions that we receive from participants prior to the project. So to start off, I put in a picture of our org chart at the Comptroller's office, because the Comptroller's office is kind of a unique creature. Our boss is elected by the legislature. We are a part of the legislative branch. So the top half of that org chart is our administration and sort of special legislative projects. And the folks that work in that division try to provide objective guidance to the legislature. The bottom part is a lot of the brain power of the office. You see the row of squares, and I kind of group them into 3 different categories. We have our property tax experts, our state and local finance experts, and our auditors, of course. And I've circled the divisions that deal in some way or another with tax increment financing. So in some ways, it is a cross-section of our whole office. So you'll see the Office of General Counsel. I believe Stephanie Maxwell is here. She is our General Counsel. We assist the Comptroller in reviewing certain plans for approval. DPA, Division of Property Assessments, they are the repository for all TIF reporting. Office of State and Local Finances handles some approvals of like plans of balloon indebtedness, and they also, you file your report on debt obligations with them. And then local government audit. And later on in the presentation, we'll briefly talk about GASB Statement 77, which just came out in August. And local government audit is probably going to have more of a role with TIF in the future. So the basics of tax increment financing. To me, tax increment financing is the act of borrowing against a future value. And I did a version of this presentation at the Assessor's Retreat recently. And the example I gave was student loans. So I think a lot of people are familiar with that, and I'm personally familiar with that. So before I went to law school, I took out loans, and during law school as well. And I was not able to pay back those loans until I had a job and an income. So I borrowed against my future income. TIF is very similar to local government, borrowing against a future tax revenue stream. And in plain English, it's upfront cash to construct a project. Now in Tennessee, there are 3 types of authorized issuers. There's housing authorities. And I guess I'm curious, how many folks in the room are staff to housing authorities? Okay, so there's a few. And then there's industrial development corporations, or IDBs. And I'm curious, any IDB staff here? Nope. And then community redevelopment agencies. And this is uncodified. You have to actually go to that public chapter from 1998. And that only applies in Shelby County and Madison County. And I made a kind of bullet point here. Please note that only IDBs are authorized to pay direct costs with tax increment revenues. Because for the most part, TIF is debt, and it's used to pay debt service. But IDBs are allowed to use tax increment revenues to pay direct costs to authorized projects. So in the code, if one of these crosses your desk, the housing authorities were authorized TIF, the ability to issue TIF or tax increment revenue notes in 1978, IDBs in 2004, and then of course the Uniformity Act came into place in 2012, and that the legislature passed it at the encouragement of the Comptroller's office, and I will go into it in a little bit. So it's important to note that TIF is a transaction. It's a big stack of documents. You're going to have your authorizing documents and your financing documents. Your resolutions approving the plan, and then you'll have your agreements that govern the flow of funds during the construction of the project and then during the life of the debt. So here's my little simple flow chart. It basically shows an IDB approving an economic impact plan, and then the city and the county will approve it as well. And then in some circumstances, it will come to the Comptroller's office or the Commissioner of Economic and Community Development for approval. And once that happens, you've created your zone, and you can start sweeping revenues into your fund. Here I just put up a few examples of financing documents. Obviously, if you guys are professionals, you're familiar with all of this. But for those of you that are newcomers, an economic impact plan is what they call an IDB tax increment plan. For housing authorities, it's called a redevelopment plan. And the debt instrument is actually called a tax increment revenue note. And it is similar to a bank loan. It's signed by the lender and the issuer, and it's not anything you can get online and read about. There's no offering statement. It's not publicly offered. I always look at the development and guarantee agreements when I'm reviewing one of these, just because it shows how much interest the developer has in the project. There may be provisions in there where the developer agrees to fill any shortfalls if the tax increment revenues don't come through. So authorized TIF projects. I find this to be an area where there may need to be some clarification. I've reviewed the statutes and I've surveyed the practitioners, and I find it rather convoluted. But in general, housing authorities, they can do redevelopment projects or urban renewal, and it is tied to blight. And the Comptroller's Office does not make any kind of blight determination. That is not our role, and that is very much a local government issue. I think another question we get a lot about authorized projects is, how do they need to be publicly owned? Do they need to be privately owned? What are the parameters there? And I would say that I guess privately owned is okay if you have parking, infrastructure, site prep in the housing authority context. And then, of course, if you want to do facade improvements to privately owned buildings and you have an urban renewal plan in place, that is okay as well. But when urban renewal plans are in place, you're kind of looking at the definition of rehab and what the parameters are there. For IDBs, it's much broader, the authority. You've got 24 subparts defining economic development. And if you do a privately owned project, you just come to us for approval. So it's more lenient. So the Uniformity Act 2012, it addressed a few specific issues. One in particular was that there was no state oversight in this area of local finance. And TIF revenues could be accumulated off budget, meaning if the principal and interest of the debt in that plan area had been paid down, the tax increment revenues could continue to be swept into an account and sort of used as a reserve or a slush fund. And there were also inconsistent reporting requirements. And the 2012 Act applies to newly created or amended tax increment plans for which public hearings are held on or after March 21st, 2012. So, in response to the lack of state oversight, the legislature instituted this best interest determination. So if there's a plan term that extends beyond 20 or 30 years, depending on the issuer, it comes to us for approval, and also the Commissioner of ECD. And then, of course, like I said earlier, if it's privately owned, it will also come to us for approval, and general economic development purposes for IDBs. And 923-103A2B is basically the slush fund prohibition. It basically says if you have not incurred debt in your plan area, then you cannot be sweeping revenues into your TIF fund. It needs to go back to the general fund. So if you're wondering, we've issued about 6 best interest letters in the past 3 years, so not too many. One, Sulphur Dell site was for a housing authority. They were asking for, approval of an extended plan. This was for the baseball stadium. We've received mostly IDBs issuing debt to finance privately owned projects, and we've been doing the necessity test and issuing those letters. And of course, those are all open to public. If you'd like to request the approval letters, we're happy to share. And last but not, this is the reporting. Basically now all creation documents for TIFs as well as annual financing statements will be filed with our office. So if you'd like to get any of that information, just do an open records request to our office and we're happy to share. And by October 1st every year, the incremental agencies need to be submitting these reports. So if you have clients that you know have TIFs and haven't submitted this type of report, it would be good to inform them. There's no penalty currently, but that may change eventually. And here's our website. Just go to publications, scroll down to tax increment financing, and you'll get the different, there's TIF reporting memo, which lays out some of our requirements when you're applying to get an approval of a plan. And also gives some guidance in the way of how to report your incremental revenues. And this slide came from Barry Munson. He kind of spearheads our reporting. He said that compliance level is currently pretty low. So please encourage your districts to file their reports with us. And it's improving because we've been sending out correspondence reminders. But one interesting thing he's doing, he's getting the comptroller field staff to contact all the assessors around the state, all 95 counties, and to put together a database that has all the active TIF districts in the state. We're hoping to get this done within a year, if possible, and have that on our website to share. Graceland, I was just going to go over briefly because this is one that crossed my desk recently. So when you're looking at a tax increment plan, these are the things to look for. Obviously the length is important, whether it's 20 or 30 years, or the amount, the cost you need to do the project. Setting your base tax, do you want to use a total area calculation or a parcel by parcel calculation? And of course your boundaries. So this one made the Wall Street Journal. I'm not sure if y'all saw this last week. It said Elvis and the hunk owed tax credits, I think was the headline. But I thought it was kind of an interesting transaction. It's basically they were financing a privately owned archive studio, hotel, conference center, museum attractions, and retail. It passed our necessity test. We approved it. The boundaries were limited to the 120-acre campus of Graceland. And from the very beginning, they were sweeping 50% of their incremental revenues back to the local government. So it was interesting because the TIF was overlapped by a tourism development zone, so they were able to pool sales tax revenues, property tax, tourist surcharges, and borrower sort of backup payments. And it was good. So this is my last slide before I hand it over to Kelsey. We get a lot of these questions like, how do you tell whether a TIF is effective or will be effective? And we don't really have a magic formula. Hopefully what you've gathered from what I've presented is, you have to use your judgment and you have to ask questions. And I mean, if I were a council member looking at a TIF, I would want to get updates from the finance director on what's outstanding and which plans have ended, and just getting a good overview of what's going on, and doing my own necessity test. Now, our standard of review is not very rigorous, so perhaps if you're authorizing one of these, you would want to have a more rigorous standard, but it's still a standard nonetheless. And ask questions about these projected values. And ask questions why the boundaries are broad or narrow. And then always remember that IDBs can use incremental revenues to pay direct costs, but housing authorities, it needs to be tied to debt. And I'm going to let Kelsey take over. Thank you.
Thank you, Betsy. I'm going to talk just a little bit about required disclosures, and then we'll move over to some slides that basically are built around questions that we receive in advance. And I'd also like you all to weigh in as we'll deal with those who submitted questions first, but we invite you to submit questions of your own, whether you're new to this process or even if you want to raise a question that's, a little deep in the grass about some of the minutia of the process and so forth. We'll take those too. May not have answers, but it'd be good to hear the questions so that we can go back and build an answer database. And we're also happy to take answers from you. There are some practitioners here who have long experience in this area and in public finance generally, and I'm sure they'll be happy to offer their insights. This slide, TIF at a turning point. The Governmental Accounting Standards Board has wrestled with this question of really the larger question of how to make sure that financial statements of state and local governments reflect the impact on fiscal capacity of the state or local government of exemptions or things that are like exemptions. And that's what GASB 77 is basically about. It's a fairly lengthy document, but it goes, and it doesn't displace any of the reporting that's already required pursuant to that state's law, but basically it will say that if I am a government accountant or accounting for a governmental entity and I'm preparing financial statements, those statements after a certain date that's discussed in this slide must accumulate aggregate information about property that's otherwise taxable but is exempt, or that otherwise benefits from a tax abatement as defined. TIF is a kind of special case of abatement. Not every TIF would meet the definition of an abatement, because if you'll recall, we talked about the TIF incremental revenue being used for public infrastructure in some cases. And certainly if the particular item of public infrastructure has been budgeted by the local government, and the local government is just counting on the TIF incremental revenue to fund that, then there's no tax loss from a budgeting standpoint to the local government, because it's a publicly owned item, and the taxes that otherwise were meant to pay for that will indeed get there. It's just that they'll get there via the TIF increment route rather than the normal budgeting of property taxes route. But it's certainly true, and particularly with these IDB TIF plans, that substantial portions of that TIF increment will flow to the owner, the private owner of a project, for example. Okay? And in those cases, it's not that the property is enjoying an exemption. It's that the tax upon that growth in value within the TIF area will be diverted. It will no longer go for the general budgeted purposes of the city or county, but rather will be dedicated to the costs of the project or the other aspects that have been identified in the TIF plan as being appropriate costs to be paid by the TIF increment. So two things to note about that are that TIF may or may not meet the definition of an abatement, and if it doesn't, then it doesn't have to be separately aggregated and identified in the financial statements. But if it does, it must indeed be noted in the financial statements, probably as a note to the statements themselves. And it's noted in an aggregate form. All the other reporting that's required by existing law for pilot arrangements through an industrial development board or for the reporting for TIF purposes are project related. So you'll see numbers associated with a parcel of property or parcels of property. Whereas with the GASB 77 financial statement notes, that'll be an aggregate. I'm assuming that there may be one or more notes, but they would deal with the diversion of revenue or the loss of revenue due to an outright property tax exemption or a pilot agreement. They would deal with that on an aggregate basis. You can expect, as these requirements come into play, and you can see from this slide, that they apply to fiscal years beginning, after December 15th of 2015. The date is soon upon us, but of course most fiscal years in Tennessee begin in July 1. So as a practical matter, you're going to see those coming into play on financial statements that cover that reporting period beginning July 1 of 2016. Okay? And, if a question occurs to you about that, for example, if you've got a question right now about GASB 77, it's okay to go ahead and raise that now. If you've got, as a practitioner, if you've got a comment that might be helpful to the rest of us in understanding how this new GASB reporting requirement might play out, feel free to volunteer that. Economic development policies. This was a pre-submitted question, and the next slide begins with that question: should policies be required? They're obviously reflected in the fact that unlike a pilot arrangement, every participating or affected city and county where a TIF is concerned must approve that TIF allocation. Okay, the TIF allocation will not apply as to a city, for example, that says we don't want any part of it. Their property taxes will continue to be paid like a base tax entirely to that non-participating city. That's not the case with an IDB pilot. There have been some recent changes in the IDB pilot law that now do require, in some limited instances, for all participating or all affected jurisdictions to join in approving the pilot arrangement. But the general rule has been that a city industrial development board could negotiate its pilot payment and keep all the proceeds, not share any of those proceeds with the county in which that city sat, even though the arrangement's going to affect county revenue as well as city revenue, and vice versa. The county industrial development board can negotiate the deal and leave the city out, even though the project property will be exempt from property taxes if it comes under the normal pilot regime. Okay, but TIF is different. TIF cannot involuntarily affect a jurisdiction whose property tax basis would otherwise be affected by that, the diversion of that TIF increment. So, should policies be required? Well, if you're here on behalf of a city or county, you're probably going to say yes. We want to. I suppose that you could wait until the plan comes to you to be approved and develop your policies about how you'll weigh a particular project on an ad hoc basis. But I would think what you do would more likely follow the pilot regime, where most cities and counties that formed an industrial development board say, that these are our standards. We'll abate property taxes to the tune of, for the first 5 years, it'll be 25% of what the taxes would otherwise be. That's a typical pilot arrangement. But in order to qualify, they must bring this level of investment or this number of jobs or these kind of paying jobs. They can establish whatever criteria they want and lay that out as marching orders to the Industrial Development Board. And if the Industrial Development Board doesn't see it their way, they can exercise their power to abolish, recompose the Industrial Development Board. So they have some control that way. But again, if you're a county IDB, you can leave the city out as a general rule. Again, recent amendments have limited the effect of that possibility. But with TIFs, again, I think the better practice would be if you as a city or county envision that the redevelopment agency or the IDB is going to come to you and want you to approve these plans, go ahead and let them know what your criteria are, what you consider to be a plan, a TIF plan that will realize identifiable benefits to the city or county, the citizens, to offset the cost of diverting property tax revenues. How should the established criteria be communicated? That's an a communication issue. And again, I would anticipate that there would be workshops or events at which new members of the Industrial Development Board or the housing agency would be made aware of the criteria that particular city or county that might otherwise be affected by decisions of that TIF agency, to communicate the criteria that's been developed. Should TIF projects be targeted and temporary? How do we know when they end? The questioner is probably, I don't know for sure. I didn't see where these questions came from, but we might assume that could be just an interested citizen or the owner of an existing business that might wonder how their tax bill will be affected if there's a diversion of some of the property taxes. It might be a school board member who wants to know how their budget would be affected if indeed all the growth in taxes within a particular area are going not to the school budget as normally formulated, but to promote infrastructure or investment within that TIF plan. So obviously they must be temporary. You must, as part of your plan, identify the term of that TIF allocation. And in some cases get approval if the term exceeds a standard set forth in the Uniformity Act or in the particular specific authorizing act. And how do you know when they end? Well, as this next slide intimates, all this must be done in the sunshine. I'm not aware of any provision that takes any of the decision making regarding either pilot arrangements or TIFs out of the sunshine, which means that decisions must be made pursuant to public notice that meets the specific TIF statute as well as the general open meetings notice law, sunshine law. And when the decisions are made under the Open Meetings Act, those decisions would have to be made pursuant to a notice given of that meeting. Those are the twin pillars of transparency, that you give adequate notice and then you don't conduct business pursuant to that notice without making sure that it's pursuant to the details of that notice, the time and the place details. I have no reason to believe that the sun's not shining right now on any of these discussions, that they haven't previously in the case of TIF or pilot. But occasionally you'll see an article in the newspapers, and the newspapers, of course, are the vigilant guardians of those open meetings and transparency requirements. What are the pros and cons of reauthorizing a tax increment allocation when the original plan has run its course? Well, that's going to be a case-by-case analysis. Is there a justification for looking at an allocation plan and saying, well, we need to run the thing out a little more. It didn't quite pay all the bills for recasting the infrastructure within the TIF area. It didn't quite get all the debt paid for the project that we envisioned here. Or we want to, we've decided that there was more demand for that particular service within that area, and we want more infrastructure. We want to expand that project that was authorized previously. So I can envision there would be circumstances warranting an extension of the plan, or it may be better to simply let that plan lapse and start a new one based upon new studies indicating need and the public benefits that would offset the cost of the TIF allocation. If the decision is made to amend the plan to keep developing the area, what questions should the authorizing entity ask? Well, that goes back to the criteria you've established. Unless you've revised them, then presumably you'll apply the same kind of criteria. But criteria are a shifting sand. The city or county governing body can make its own decisions and revise its decisions going forward as to how it will weigh the costs and benefits of a TIF or a pilot arrangement. What oversight authority does the comptroller have? When is it exercised? What prompts it to be used? I think Betsy has pretty well covered how the comptroller interacts with these plans. The most direct impact, of course, is when in those limited instances where the term of the deal exceeds the specified statutory term, or where the uses of the TIF increment are beyond or not within the stated purposes in the TIF law. And you've heard that process described. A letter goes to the comptroller, probably going to get routed to Stephanie Maxwell in General Counsel's office, and they'll review it, make sure that it meets all the requirements for form that are either explicit or implicit in the statute, and then forward that to the comptroller for that decision. And then concurrently, of course, that's to happen at ECD, and you can expect that if you've forgotten to include ECD, that the comptroller is going to make sure ECD coordinates, so that you don't get half an answer. But there is other oversight. You've heard the role the comptroller plays in property taxes generally described, and it's a big role. It's been a big role since question 3. It's been a big role since the early days of Tom Fleming, for example, and it continues to this day, and there's been no sign that the legislature wants to diminish it. It's based on auditing, the idea that there needs to be an independent review of whether there's compliance with program measures and compliance with financial accounting standards that are expected of any governmental entity. In some cases, there's more specific oversight. Two of the most important local officials, once these plans are approved, are going to be the assessor and the trustee. And I've got to say to you right now that the level of explicit direction to the assessor and trustee about how to do their jobs in the business of assessing property and determining how much of the assessed value of property is part of the base year assessment and how much is part of the increment. The job of receiving that allocated revenue and make sure it gets to the right place. Those tasks fall upon the assessor, and the collecting official, the trustee or the city recorder. So those offices are subject to audit by the comptroller's office. They'll be looking to see if allocations have been made, not just consistent with the approved budget for that city or county, but also with regard to this increment, if it's to be allocated and used in a specific way. I think you can expect an auditor to take an interest in that particular area. I don't pretend to speak for auditors. Auditors and lawyers are different creatures and go by different, have different insights. They're certainly created equal, but I had great admiration, nothing but admiration for auditors. Once upon a time, I was in a meeting with Art Hayes, and we were talking about the perpetual conundrum of what does the comptroller do about auditing itself. That too, the comptroller must be audited, and yet there must be a means to do that that's independent. And I made the remark that as far as my little division, I'm probably one of the smallest divisions in the comptroller's office, and I didn't feel very audited. And boy, was that a mistake. The next audit cycle, Art made sure I felt audited, and it's good. It's a good thing. I'm a wholehearted proponent. I drank the Kool-Aid long ago for accountability in government, going back to the Snodgrass years. What other resources are available? Before I leave the assessor and the trustees' roles, I think just from a personal note, I think there are others who agree that we need to lay out better directions for assessors and trustees about their role, because it is, as we see TIF used more often, trustees and assessors are going to have to be conscious of their role. And those are elected offices. And some of them are very small offices. And when they turn over via elections every 4 years, you've got a chance for something to fall through the cracks if they're not aware of this particular area of their responsibility. The Division of Property Assessments is good, again, an agency of the Comptroller's Office, about making sure that assessors, particularly new assessors, are aware of their responsibilities. But again, their focus is upon the basic functions of assessing property and making sure things aren't exempted that shouldn't be, and so forth. So TIF, particularly in its expanded usage, is kind of a new area. So I think that's one thing that we're going to have to do, is make sure we have good direction to the assessors and trustees. The other thing is that the Uniformity Act makes provision to fund the additional responsibilities of assessors and collectors through the proceeds of the TIF. That was not heretofore a feature of tax increment financing. Presumably the city or county in their budget made provision for those two offices to do their jobs. But if there are additional functions, if there are software updates or hardware updates that are required to allow an assessor or trustee to do their job here, then the TIF pool is available up to 5% under the uniformity law to cover administrative costs, not just the assessor and trustee, but certainly including the assessor and trustee. So that's an explicit source of funding, of meeting those expenses, those needs, and should be recognized and utilized where appropriate. And I think that's about all. There's the roadmap. Get your copies now. I think they're going quick. And I'll refer you to my agent, John Dunn, the Public Affairs Officer of the Comptroller, to make sure that happens. He keeps me under rein anyway. So, any questions that we've not covered? And as I said, are there any observations that those of you who have long experience in this area would like to offer? Are there challenges that you foresee in the broadened usage of TIF as a means of financing economic development locally? We'd love to hear from you now, and I'm sure those who are attending with you would like to hear from them too. I'd also like to invite any members of the Comptroller's Office, if I've misstated or encroached into the territory of the auditor, certainly I want to beg their forgiveness and invite their input at this time. So, questions? Any questions or comments about anything you heard? Any disagreement with anything I said or Betsy? Okay. Yes.
Right now, all this is disclosures. It doesn't affect the financial statements and any net position, any asset, any liability. That's perhaps in the future, but it's not right now in the statute, or not in the statute, but in the standard. So it's only disclosures in the notes to the financial statements. But because it's in the notes to the financial statements, that means that information has to be audited, just like it was on the financial statements. The other thing is that right now, the way the disclosures are written, all you're going to have to show is the abatement for the current year. In other words, you're not talking about abatements for the next 20 years and putting that number in the notes of the financial statements. It's just the amount of tax revenue foregone or abated for the current year. And so that, I think, is fairly significant.
Okay. Did everyone hear Jerry's observations about the GASB reporting, the impact on GASB reporting? Right now, the board maintains a link at its website that compiles pilot payment information. You know, the beneficiaries, the businesses who use pilot property, not TIF, but pilot property, have to annually report by October 1 the certain information about the fiscal impact of that pilot arrangement. And you can see that information. We summarized it in a spreadsheet that's available in a link at our website. And you can expect to see that in the future for TIF arrangements as well, a kind of a cataloging of the arrangements and some attempt to extract information from the annual reporting that's required for TIF. You know, that allocation, we have to have a means, a report that the allocation has indeed been paid. This is the amount allocated and the amount reserved that otherwise will go where it was originally budgeted. So the new reporting under the Uniformity Act for TIF will also begin to show up at the Comptroller's website at some point, we can say safely. So,
Kelsey, one other thing I
yes,
mention
please.
Is if you've got several of these either pilot or TIF arrangements that meets the definition of a tax abatement under GASB Statement 77, they may be going back 10, 20 years. And so the time to start gathering this information that's going to be presented as a disclosure is now, because it may not be as simple as it seems like it would be to gather this information. And there will be all kinds of different degrees of organization in different governments. Some will have put it on a back shelf and put it in the basement. Some will have it first and foremost lined up in a row. So auditors are going to need that information. We will need that information effective June 30, 2017. And believe it or not, now is the time to start making sure each piece of this disclosure is in place.
I doubt we have any accounting staff for cities or counties, but we'll be taking steps to get that word out. Certainly, we speak to the society every year about various tax implications, including property taxes, for my part, and we'll be certainly mentioning the issue with GASB reporting. Yes, David.
Could you address the ownership of this debt? Whose books does this debt normally go on?
Betsy, you'd weigh in on that. I'm thinking it's the
TIF
TIF agency.
Guys here, but the ownership of the debt, obviously, if it's a housing authority that is issuing the revenue note, it's going to be in their name. And if the Industrial Development Board is issuing if they're the ones signing the note with the bank, then it's going to be in theirs. Now, if you want to split hairs with accounting standards, whether it's a component unit and all that, I can't really go there, but it's in the Industrial Development Board's name or the Housing Authority's name. So it's an on behalf of entity.
Can the debt be in the name of a private concern, that if it's funding a private facility?
These are not in the private, and I defer to these guys, but these are not in the private entity's name.
Sometimes on the reimbursement TIFs, they agree to reimburse the developer, and the developer then borrows against the reimbursement. That's not a common structure, but theoretically it can be done with an IDB TIF.
But for the most part, it's housing authorities and IDBs. It's in their name.
So the general rule is that it's going to be in the name of a public entity. The debt will be. Occasionally there might be a private beneficiary who's got its own debt.
Because housing authorities are audited, correct? Not all IDBs are audited separately, right? They might be a part of the counties or city. Or we'll learn this.
Most of them are separate.
Okay. That's who's going to be holding the debt.
So the example would be, let's say I had a housing authority and we have a development project, and for instance, we borrow the money and potentially there are these beneficiaries, so we act as if we're a conduit and we loan the money to the beneficiary.
Right.
So we would have the overall debt that belonged to the housing authority, and then there would be these individual transactions that would be repaying the debt of the housing authority. So if you had a situation like that, wouldn't the original debt be the debt of the housing authority, and then you'd have a second set of transactions where you were recognizing basically an asset with a loan of that money?
Ron, we're going to let Mark Mamatoff weigh in on his view about that.
There's no mechanism to actually loan to a private entity from the housing authority. The money's not loaned to them. It's used to pay eligible expenses directly by the housing authority, typically to a land write-down or by agreeing to pay other redevelopment costs under a development agreement. So there is no loan. It raises a really interesting federal tax issue from the developer standpoint. If you grant funds to them, do they have taxable income due to the grant? If it is private property that's not structured right, they may end up with a huge tax bill that they're not expecting, and so we always try to caution folks about that. So there is not a concomitant loan to the developer. They have no debt on their balance sheet due to the TIF. They purely have an obligation to do whatever's required under the development agreement. Frequently, there's a guarantee in the development agreement where they agree to make up shortfalls. And so it's a secondary liability. I wouldn't think it would show up probably as a note on a balance sheet of the developer, but it's not direct debt. It's a backup to the housing authority obligation.
What's an example of something like he's describing? Would it be maybe like a sports authority that enters into a loan agreement?
Yeah, some of the IDBs you can combine it. That's a different animal.
Right.
Ron, you mentioned housing authority. With an IDB, theoretically, you could issue debt backed up by the TIF and loan the funds, because the IDB has the legal authority to directly loan money to a private party, unlike the housing authority. That's
Kind of different than the housing authority.
No. Please.
I said I'd like answers as well as questions.
Yeah.
Anybody else that has a thought or an observation about that, if you've got experience, please share it.
I guess I'm wondering where the question is coming from. Are you, as an auditor, kind of trying to follow the flow of funds, or I mean, what prompted that question?
With the ownership?
Yeah.
Yeah. Well, what you normally explain is sort of the vanilla version.
Sure.
But there's always multiple layers. You borrow money, a bond's been issued to fund the TIF, and then they borrowed money back, and then like I said, you're just trying to track who the debt is should sit on whose books, who's responsible for it, and that's like I said, your versions are vanilla versions of it, and what we normally see have multiple levels of complexity because of if you just went to a bank to borrow,
right,
simplistic. We have a lot of transactions that are internal and same entities
okay.
We're just trying to untangle a few issues. That's what we're trying to do.
In the redevelopment TIF, one of the requirements to be included in the plan is an estimate of the amount and final maturity of bonded or other indebtedness to be incurred by the redevelopment agency. So you'll get some detail in the plan itself. And remember, those plans are coming to the comptroller's office. You've got to file those with the comptroller as well as locally. So that will be an opportunity to analyze the plan and to raise questions about how it's structured or the debt that's identified and so forth. I think there's going to be an opportunity to kind of dig below the surface on some of the details. Again, that may come about as part of the auditing process, or it might be a compliance question that you may get. But But hopefully the plans themselves that we begin to receive will offer us some insight into the usage of the debt and who's responsible, who's incurring the debt, and so forth.
And that's for transactions after 2000, whatever that date is in 2012.
Well, no, these plan requirements are in place now. In fact, they've been around for redevelopment projects for quite a while. The Uniformity Act did nothing to take those away. It just tried to, in some cases, make the requirements between one TIF authorizing statute and another consistent. So, but basically, none of the existing TIF requirements were affected by the Uniformity Act, other than to superimpose some uniform reporting requirements and that sort of thing. And GASB is strictly a measure designed to improve the usefulness of financial statements. That particular process, it does indeed apply going forward, but all the plan requirements have been around for a while. But they haven't been necessarily reported to the comptroller until the Uniformity Act, which passed in 12, so it probably didn't start taking effect until 13. And we're still getting worded out about that, as Betsy was explaining.
Betsy, if a community is looking at establishing a TIF, would your office be available to come in and help us or help them figure out which path to take in steps?
Within certain boundaries, obviously, I'm not serving as your attorney or counsel,
Right.
so I can advise as to how we read the statute and what the requirements are. But I can't obviously opine as to the legality of that transaction. Like I said, objective guidance. We're good. Yeah.
So,
Thanks for coming.
Yeah, hope this is